we are back, and we are joined now by Randall Eliason, professor of white-collar criminal law at George Washington University Law School, former assistant U.S. attorney for the District of Columbia, where he served as the chief of public corruption, government fraud section, and author of the blog Sidebars, where you can get all this up-to-date legal information on Trump and more. Randall, thank you so much for coming on the show today.
Sure, my pleasure. Thanks.
So we had a viewer write in last week and saying that they're having a bit of trouble keeping track of Trump's various legal battles because there's a lot. And they would love if we had an expert on to discuss this. So you were the man to call. How many indictments are we currently at right now with Trump, numbers wise?
So, and it's not just the criminal matters, of course. There's the civil matters that are in the news a lot as well, like the civil fraud judgment and the huge bond he was required to post and things. But the criminal cases, there are four. Four criminal and one in Florida. And then two state cases, one in Georgia and the one in New York, of course, which is actually gone to trial and going on right now.
Yes, the one going on right now, it's literally as we speak. Yesterday was the first day of that hush money case, that hush money trial. We're in or not maybe the first day. It was the first day of oral arguments. I apologize.
Right.
What did you observe on yesterday when oral arguments opened up?
Well, I don't think there were any big surprises. I mean, the case, the actual criminal charges are not terribly exciting. They're kind of a bookkeeping charge. It's about keeping false records in the internal records of the Trump organization, 34 different counts of that, where the state claims that they recorded these expenses as legal expenses, payments to his attorney, Michael Cohen, when really what they were for were not legal expenses, but to repay him for the hush money payoff to Stormy Daniels. So the kind of big picture is the state's argument that this was all a conspiracy to cover up the hush money payment that was made right before the 2016 election, which was to try to influence the election, keep that damaging information away from the public. But the thing is, the hush money payment itself is not a crime. There's nothing illegal about that. So they it's almost like this judo move. You know, they take what's actually kind of a boring and technical charge of false business records, but the reason he did that was to conceal this hush money payoff scheme. And so they actually characterized the case as being about election interference or election fraud, that this was really all about trying to manipulate the 2016 presidential election. And these false records are just a sort of sign of that, or one way to try to continue that cover up, even though the records were actually made after the election. So the records themselves couldn't have, defrauded any voters or influenced the election at all.
Well, you actually, I read one of your articles on your website, Sidebars, and you made the point that you feel like the election interference piece of the prosecution's arguments maybe not the strongest. What's your reasoning behind that?
Just sort of what I said. It's a way to characterize the case, kind of the atmospherics. That's the way kind of they're portraying the case to the public. But legally, it's really not. This really is not about election interference, because, like I said, the false records that actually form the basis of the actual criminal charges, they were all made after the election was over. So how do they interfere with an election at all? And even the hush money payment itself, well, that was to try to keep damaging information from the voters. Sure. So they were trying to influence the election, but politicians do that all the time, right? Politicians are always trying to manage damaging stories and keep them from coming to light, things like that. And it was not otherwise illegal. So now is every time a politician tries to keep some damaging story out of the news, is that election fraud or voter fraud, election interference? So I feel like the way the public portrayal of the case, or the prosecutor's kind of theme of the case, and saying, oh, this is really about election fraud, so the kind of way to kind of dress up what's otherwise a kind of boring and technical charge of, making false records and make it sound more significant than I think it actually was.
So there are those three pieces, right? The violation of federal campaign finance law, the violation of state campaign election law, and then the violation of state tax law. So your assertion really is that it's that third piece that has the strongest case.
The tax law?
Yes. Yeah.
Well, yeah, I don't think any of them. I mean, so those are the three laws. to make this charge a felony, as you know, the state has to allege that these business records were falsified in order to conceal some other crime, and that otherwise it's just a misdemeanor. And so what they alleged before trial was that there were 3 other crimes that they were actually trying to conceal. One is a federal election violation, illegal contribution to the Trump campaign by the payoff to Stormy Daniels. The second is a state election law violation, and the third is a state tax charge. Yesterday, they seemed to emphasize primarily the federal election charge. They didn't really talk in the opening statements about this state election charge or the taxes, but I mean, they could still come back to that. But they've got alternate theories about, what the underlying crime is that they were trying to cover up. And again, they don't actually have to prove that crime was committed. They just have to prove that the intent to conceal that possible crime was part of the motive for falsifying these records.
You briefly cut out, so we didn't get really the end of your sentence there. But my question really to you is, are they going for the federal election, opening with the federal election angle, basically, because Michael Cohen has already served time and confessed to crimes in this area? Yeah,
I think that's probably a good part of the reason. They feel that's their strongest theory, I think. And like you said, Michael Cohen already pleaded guilty to basically the same crime. So although they don't have to prove that Trump committed the crime, that's probably the easiest thing for them to hang their hat on when they're trying to say there was this other crime that they were trying to cover up by falsifying these records.
Right. And yesterday, the prosecution's leadoff witness was David Pecker of the National Enquirer. And you said early on in when we were speaking that hush money payments in and of themselves are not necessarily crimes, because there's the Karen McDougal piece that I'm wondering if you could expand on. It's the falsification of the records that constitutes these charges. Right.
I mean, the catch and kill scheme, as they call it, buying the rights to a story and then deciding not to publish it, that's perfectly lawful. I mean, it's a contract. I can buy the rights to your story, and then it's up to me what I want to do with it, including if I want to bury it. So there's nothing illegal about that. But the crimes related that Cohen pleaded guilty to related to considering those catch and kill payments to be campaign contributions. So the McDougal payoff by Pecker and National Enquirer, that was alleged to be an illegal contribution from a corporation. And then the Stormy Daniels payoff from Cohen was alleged to be an illegal contribution from Cohen that exceeded the lawful limits. So both of these schemes were portrayed as crimes, not because the scheme itself is illegal, but because doing it to further Trump's presidential ambitions was considered a contribution to the campaign, and so therefore needed to be reported or couldn't be made by a corporation. And that was the criminal hook. Yeah.
And the 34 counts, is that because that was made to Michael Cohen in dozens of payments? This is spread out to falsify it?
Right. They took the payment so he made the payment to Stormy Daniels out of his own money. He took out a home equity loan for $130,000 and wired that. So they were paying him back. So it was that $130,000. There was another $50,000 that he had paid to a consulting firm or a polling firm. I think during the election they were reimbursing him for that as well. They tacked on, they called it grossing up, a bunch of extra money because he was going to have to pay taxes when this money came to him. Purportedly for legal fees, it was going to be income, and he'd have to pay taxes on it. So they added another $180,000, I think it was, to help him cover his tax bill, and then the rest was a bonus, just a bonus to him, $60,000, I think. So the grand total was $420,000, and they said, "Well, we'll pay you that monthly, $35,000 a month for the next year." And so every month, Cohen sent them an invoice saying, "Here's my bill for legal services rendered pursuant to our retainer agreement." Well, there was no retainer agreement. And right. The state's arguing there were no real legal services rendered, although it sounds like the defense is going to claim that there were, and that these were actually legitimate payments, for legal work. But so it was monthly invoices and monthly checks and monthly recording of the payment in the ledgers of the Trump organization as legal services, which the government says was false. So every month you've got 3 different records, except for the final month. A couple of them weren't made for some reason, so they ended up with 34 counts, 3 a month for the 3 different ways these payments were falsely recorded in the Trump books.
What's your, after this first day of oral arguments, what's your assessment of the prosecution and how they performed?
Well, of course, we can't see it, right? We're at a little bit of a disadvantage with no cameras in the courtroom. I mean, it doesn't sound like any surprises, like I said earlier. And I think the state has a strong case on the facts. I mean, the documents case like this, they tend to speak for themselves. You know, the documents say what they say. And I think it's going to be pretty clear that they were false. I mean, the defense really, from their openings, the defense opening was a little more surprising to me than the prosecution. I thought the prosecution was kind of what we expected. You know, this was really about election fraud, election interference, and that's why they falsified these documents. You know, Stormy Daniels is lying, Michael Cohen is lying. The records really were for legal services. You know, that's a pretty aggressive approach. You know, they could have said, well, yes, he was trying to conceal this, but that was because he was trying to protect Melania, or he'd wanted to avoid public embarrassment, but it wasn't really anything to do with election interference. You know, they could have taken a more compromised approach and try to convince the jury that really this was just maybe a very technical violation, but no big deal. But they're going all in, and they've got to say everybody's lying. And that's pretty difficult for the defense, because the case is not going to rely just on Cohen and Stormy Daniels. There's going to be a lot of things that back them up. You know, other witnesses, other documents, and then the records themselves. So I think it's an uphill battle for the defense. I think the states, on the facts, like I said, have a strong case. I think there are some legal potential issues with the case, and that I've written about on my blog, but you know, those most likely won't show up until there's an appeal if he is convicted.
Can you expand on some of those issues that could potentially crop up if he appeals?
Yep. I mentioned earlier, I think there's a question. So even to make this a misdemeanor charge, the state has to prove intent to defraud. And I think there's some question about how these are purely internal records of a private company. So these aren't submitted to any regulatory agency. You know, they're not filed in public filings like a publicly traded corporation files at the SEC, anything like that. It's almost the equivalent of making a false entry in your own checkbook register at home, right? No one else has a right to see it. So how do you prove that that was made with intent to defraud anyone? And especially, how was it made with intent to defraud the voters when the records weren't made until after the election was already over? So it's kind of this convoluted, after-the-fact cover-up theory that just in case anybody did come looking, like the Federal Election Commission 2 years later comes looking at the records, or someone else, other investigators, well, we'll have this phony paper trail to help cover it up. That seems to be the state's fraud theory. There don't seem to be really any cases in New York that support that, although former members of the district attorney's office say they think it's common, you know, that it's not unusual. But the fact that the records are purely internal, no one else had a right to see them, and they weren't submitted to anybody else, I think makes intent to defraud a challenge, even for a misdemeanor charge, much less a felony charge. Well, and there are other issues as well, such as, you know, can a federal election crime be the basis of this state criminal charge? You know, that's one thing the defense has challenged. The judge for now has ruled yes, but it doesn't appear that the higher courts in the state have taken a firm stand on that yet. And there's a question of even was this an election crime? You know, the John Edwards back in the day was charged with something very similar, and the jury failed to convict him. I mean, experts don't necessarily agree that this was, in fact, this should have been considered a campaign contribution. And if it's money from Trump himself, he's allowed to give unlimited money to his own campaign. So I just feel like the charge itself is very technical. Like I said, it's kind of a bookkeeping charge. And they've really tried to dress it up and call it an election fraud case. And I just don't know if that's going to hold up in the long run.
I think your analysis, even though it's not necessarily maybe what exactly we want to hear, is accurate or compelling. And my question to you, though, is this civil fraud. I read today in the Times that the prosecution was able to either ask Trump about the civil judgment against him or basically include that within the scope of the case. Because he was found liable for hundreds of millions of dollars in that civil fraud trial just some weeks ago, does that add to the prosecution's ability to make a case that this is a part of a larger kind of fraudulent effort by this corporation and by this person?
Sort of atmospherics wise, yeah, I think that's right. But legally, it's a very different set of circumstances. The fraud in that civil case had to do with defrauding insurers and bankers, by inflating his assets and saying they were worth far more than they were to get loans or to pay lower insurance premiums. But there you're actually, giving the documents to someone. You're giving the information to someone, intending for them to rely on it. That's usually what fraud means. Unlike this case where the documents...
Sorry about that, folks. We're back with Randall. So you were mentioning that I had asked you a question basically about how the civil fraud judgment could play into the arguments in this case.
Right. And I think, as you suggested, it contributes to kind of an atmospheric argument that the fraud is part of his life, right? This fraudulent organization and lying is kind of standard business practice. But legally, it really doesn't affect these charges because the civil fraud case involves documents that were actually submitted to insurers and bankers, intending for them to rely on them, that the states had inflated his assets. But that's fraud, right? You give someone a false document intending that they rely on it. Unlike the documents in this case, which were, like I said, purely internal, that no one else had a right to see and weren't submitted to anyone, where the intent to defraud. So it's a very different kind of allegation. And then the ruling you're referring to, there's a pretrial ruling. So normally if a defendant doesn't testify, the state isn't allowed to introduce evidence of all the other bad things they might have done, just to try to suggest to the jury, well, they're just basically a bad person, so they probably committed this crime as well. That's not admissible. But if they take the stand, then all of that stuff comes in, because the state can then cross-examine them to challenge, in this case, Trump's credibility with evidence of prior bad things he's done, and including the E. Jean Carroll verdicts and the finding of sexual assault and the finding of civil fraud. So there's a pretrial hearing where the judge rules on whether those prior bad acts can come in or not if Trump testifies, because then that allows the defense to factor that into their decision about whether he should testify or not. So if he were to take the stand, then the civil fraud case and the E. Jean Carroll case and those other things would come in. But I think he's extremely unlikely to take the stand, even though he's saying he will. That would be, there's not a defense lawyer alive that I can think of that would think that's a good idea.
No.
Now, ultimately, it's his decision ultimately, and he could just refuse to follow his attorney's advice. But if he takes the stand, it'll be the best thing that could happen to the prosecutors.
Well, I mean, it's also you alluded to some of the strident arguments made by his defense team. I mean, we're not talking about the top lawyers in the country at this point, right? He's had some difficulty retaining people given his proclivity for not paying his legal bills or any bills.
Yeah, that's true. Although I think his lead counsel in this case is a pretty respected attorney,
okay.
but he's got it's not the Rudy Giuliani, it's not the Sidney Powell crowd, but he's got a tough client on his hands and he's got a tough case.
Yeah. So I guess then I wanted to turn to the other cases and the statuses there. We were talking about the civil fraud case and the judgment, and I know Letitia James is challenging the validity of his bond in the civil fraud case. What's your assessment of where he's at? I mean, and his ability to pay and how that bond plays into the outcome.
Yeah, I saw a headline just before we came on that it sounded like they'd reached some resolution.
Okay.
I haven't followed the civil stuff as closely, but it sounds like they've come up with some additional conditions that he'll agree to that will allow, and the state will then accept the bond. So maybe they've got that figured out, but I don't know all the details yet. But again, that's just to allow him to appeal, basically, right?
Right.
Just has to post the bond so that he can appeal the civil judgment. And, I don't think it would be surprising to see that total judgment be reduced on appeal somehow. But the bond, it sounds like maybe they've resolved.
But I mean, this may just have escaped my memory, but given the amount that he basically was found liable for, that he has to pay back, the hundreds of millions of dollars, why were criminal fraud charges not pursued against him?
Well, that's a great question. I mean, and it was somewhat controversial. The former DA in New York was reportedly ready to bring this as a criminal case. And then when Alvin Bragg was elected, he chose not to bring it. And you might recall there were a couple prosecutors who resigned from the office kind of in protest. They thought the case was all ready to bring. And then Bragg said, no, it's not ready. We're not going to do it. So I think a number of outside observers have asked that same question. It's like, why wasn't this the criminal case that you brought? This looks stronger. Now, as a former prosecutor, I'm always hesitant to second guess those judgments because from the outside, we know only a relatively small portion of the relevant information, right? So much of what goes on in a criminal investigation is protected by secrecy. And so there might have been factors at play that we just don't know about that led to that decision. So like I said, I'm always a little reluctant to second guess a prosecutor's motives in a situation like that. But it's certainly and we don't know, so we still don't know really the answer as to why Bragg declined to bring that case and then went back and resurrected this one, which most people think is far weaker. And this was the criminal case that he ended up bringing.
And the two federal cases, the classified documents case and the January 6th case. I know the documents one is further along. Let's start there. What's the status and some of your observations of that?
So the federal case in Florida is the documents case. That's based on the unlawful retention of the classified information at Mar-a-Lago, right? The boxes of records that were kept in his bathroom. And then hidden from investigators when they tried to recover them. Of all four cases, that's probably the strongest one. I think it's pretty open and shut.
Right.
You're just not
just
allowed
like
to
the
have...
bathroom door. Just like that bathroom door.
You're not allowed to have this stuff. And especially when they come asking for it repeatedly and you fail to return it, even if you thought initially you had a right to have it, when they ask for it repeatedly and you refuse to return it and then try to hide it from them, there's just not much in the way of a defense there. So, it's very different from finding a few stray classified documents in Joe Biden or Mike Pence's files that they didn't even know about, and they immediately return when they're found, right? I mean,
right.
This really is primarily about the obstruction and the repeated refusal to turn them over. It's not about having the documents in the first place, although the quantity of documents here is absolutely, and the deliberateness with which they were taken is also unusual. So that's a really, really strong case, but the problem is they have a judge who's really dragging her feet. And she's a relatively new judge, whether it's from inexperience or as some suggest because of bias towards Trump, who appointed her. She's just really taking forever on issues that shouldn't take that long. And it appears that case is going to drag out past the election. If it does, and of course, if Trump wins re-election, then with both of the federal cases, the assumption is he'll cancel them, right? He'll order his attorney general to just drop them. So we're in a really unique situation here, not just the Florida case, but the January 6th case in DC, the other federal case. We've never had a situation before where a criminal defendant might end up with the power to cancel his own prosecution if the case doesn't get to trial in time. So there's a lot of urgency in the DC case for the Supreme Court to decide quickly, and maybe that case can still get to trial before the election. But that window seems to be rapidly closing. Yeah. Where it would be possible to get that done.
We've covered Eileen Cannon before, the judge down in Florida, who's making the determinations really on this timeline, and the fact that she was a Trump appointee. The what you're referring to with the Supreme Court, how they're hearing oral arguments on his absolute immunity claims in the next day or so. It's widely expected that they'll basically throw it out and essentially say, there's no way that a president can claim they have absolute immunity from prosecution because of the nature of the office. That's kind of very much against the spirit of everything that America was supposed to be about as an anti-monarchy constitution, basically. But the point is really what you say, is that they decided to even hear arguments, which delays all of this because
Right.
of the fact that it's going to happen right late April. Then they can't even get started until after this is decided.
Right. I mean, they could have taken it. I mean, Jack Smith asked them to take it immediately, to skip the DC circuit altogether and just take the case. That was back in December, I think. And they declined, but then they ended up taking it in February. And we're hearing arguments on Thursday. So they don't seem to be proceeding as though they see a lot of urgency. And in a normal case, that would be understandable. In a normal case, you'd say, well, it's not their fault, when the case came to them. And why should this be sped up just because the case didn't arrive to them in time? We should just take it in the ordinary course and we'll decide it like we decide any case. There's no reason to speed things up. But this is a unique case, like I said. We've never before had a situation where if he wins re-election and this case has not gone to trial, it's never going to go to trial. And the people have a right to have these charges tried, right? And the public has a right to a trial as well, not just the defendant. And because of that, they really need to step up and accelerate this decision. But they're not showing any signs of being willing to do that.
And then how does this affect the January 6th case, the other Jack Smith federal case?
Well, that's the one that I'm talking about.
Oh, okay.
That's the one where they're arguing the Supreme Court. The Florida case,
okay.
that's just dragging on because of Judge Cannon. It's the DC
I'm sorry,
case.
I thought it affected both.
No, not really.
Okay.
No, it's it's appeal from the DC case that the Supreme Court's hearing arguments on Thursday, and of course that case has been on hold ever since Judge Chutkan denied his immunity claim. So that's the one, and that's the January 6th case in some ways, in terms of protecting our democracy and things like that. That's the most important case of all.
Right.
And if the Supreme Court doesn't act quickly enough and he happens to win a re-election, then that case may never get to trial.
And it's also concerning because the Fulton County case seems to have a lot of issues cropping up, given Fani Willis being quite reckless, honestly, with some of her personal entanglements. I know the right has seized on it, and it's not relevant, but you have to be very buttoned up when you're dealing with something that important for our democracy. I know this is not this is maybe a little bit out of your purview or what you focus on, but that's kind of I'm curious what your assessment is of that last major case that Trump's dealing with.
Right. So it's also based on the January 6th events, but even before all the distractions about the DA and the man that she hired being involved, even before that, this is just a really unwieldy case. 19 defendants, the state RICO charge. They've got another big RICO case going on in Georgia right now, where it took them months and months to pick a jury, and the trial itself is projected to last well into next year or beyond. Just because when you get that many defendants, and everybody's getting up to cross-examine every witness, and everybody's filing all their motions, and it's just an enormous, unwieldy case. So one of the things that was smart about Jack Smith's DC case, it was kind of a rifle shot. He charged only Trump, relatively narrow set of charges, gave himself the best possible chance of going to trial before the election. I think Georgia is just bogged down. It's just, like I said, very large and unwieldy case.
Too many defendants, too broad, but they would probably argue, how else can we make a RICO case without kind of expanding it to this broad conspiracy, right?
Right, but you don't have to make it a RICO case. I mean, you could have filed 3 or 4 separate smaller cases against different groups of defendants, for different aspects of the scheme, and really narrowed your focus. Or they could have filed cases just against Trump for now, thinking that they could come back later and get some of these other defendants. So, which is what Jack Smith did. I expect if Trump is not reelected, we're going to see more charges in DC from Jack Smith after the election. when it will no longer bog down his case. And he could indict some of these other 6 co-conspirators, separately in new cases. And you could have taken a similar approach in Georgia, but then instead they went all in, and
Right.
it was splashy and it generated a lot of headlines, but actually getting a case like that to trial is kind of a nightmare.
Well, really appreciate your time today and explaining this all to our audience and helping me out too in parsing this. Randall Eliason, you can read the blog Sidebars to keep up to date on this. And I saw you're also writing a bit about what's going on with Menendez and his trial as well, which maybe we'll have you back on to talk a bit about that. I'm from New Jersey, so I have a bit of a special interest keeping an eye on that.
Great.
Randall Eliason, professor of white-collar criminal law, GW, former assistant U.S. attorney for D.C., and the blog is called Sidebars. Thank you so much for your time today. Really appreciate it.
Thank you. Thanks for having me.